Yes. Hello, everyone. My name is Zheng. I'm a PhD student from the University of Groningen. Today, I'm going to talk about our paper, Hardness of Case-Based Decisions, a Formal Theory. Following precedence is a fundamental principle of case-based reasoning, but the application of it varies in complexity. Legal decision-making can still be very hard. This puzzle has been well recognized in AI and law since its early days. For instance, in Anne Gardner's landmark work, An Artificial Intelligence Approach to Legal Reasoning, she addresses the distinction between hard and easy cases by using ideas from jurisprudence. The hardness of case-based decisions can come in different types. Some cases are easier to decide. However, things can become harder. For instance, not all conflicts can be resolved, or there is no matching precedent. Significant work has been devoted to the nature and dynamics of case-based reasoning and to the hard cases as well. However, to the best of our knowledge, no formal theory about the hardness of cases has been proposed so far in the field of AI and law. So in this paper, we are going to discuss this question. Is there a typology of how hard it is to make a decision about an issue in case-based reasoning? We propose a formal approach written in propositional logic to formalize the hardness of decision-making issues with the validities of relevant arguments. We also illustrate the approach with a case study in the dynamics of case-based reasoning by following Berman and Hafner's research, thereby showing how hardness varies over time. This slide shows the 7 cases that we are going to discuss, which aims to solve tort cases about car accidents from New York. With the elements extracted from these cases, we got 7 conjunctions to represent them. They are represented by the plaintiff's name, the year of the decision, the kind of case, either a tort case or a contract case, and the jurisdiction choice rule. We need to consider which rule should be applied when different jurisdictions are relevant. For instance, when people drive from New York and have an accident in Ontario, Canada, which rule should be followed? Ontario's rule or New York's rule? Your territory is for entirely applying the territorial rule. Exception is for partly applying the territorial rule while making an exception for the damages part of the case. And gravity is for applying the center of gravity rule. In this paper, we try to apply our approach to solve problems such as if there are only these 2 precedents can be considered, how hard it is to apply the territory rule in an undecided tort case that arose after 1945. And what about the hardness of applying the center of gravity rule? And after new cases were added, does the hardness of applying rules change? And does it become harder or easier? In general, we consider these 4 issues of the New York cases, namely whether to apply the territory rule in tort case or not, whether to apply the gravity rule in general, whether to apply the exception about the territory rule, and whether apply the gravity rule in tort law. As you can see from this picture, there was an agreement in decisions that the territory rule should be applied in 1938, so decision-making was easy at that time. However, from 1945, alternative possibilities were explored. First is for contract cases, then also for a tort law case called the Cuba case in 1961. Therefore, case-based decision-making becomes harder since there are different possibilities and without a clear preference. And then in 1963, things again became easier since the landmark Babcock case expresses a clear preference for the gravity rule. Now we turn to the theory part of the paper. First, we are going to introduce case models. We describe a case model C as a set of logical consistent incompatible cases, forming a total pre-order that represents a preference relation among the cases. For example, the New York cases we just introduced can form a case model. And please notice that we consider the plaintiff names to exclude each other pairwise. And similarly, for the decision years, the kind of the cases and the rules. The preference relation among these cases is denoted by the size of these boxes. And namely, the Babcock case is more preferred than other cases, which are equally preferred. This is because the Babcock case is a landmark case that overrides previous cases, by which the center of gravity rule is established for tort law. And we consider an argument from chi to rho is a pair chi-rho, where chi is the full premise of the argument, rho is the full conclusion, and chi and rho is the full position made by the argument. According to the preference of a case model, arguments can have three kinds of validities in the model. From weak to strong are coherence, presumptiveness, and conclusiveness. The relation between these validities can be illustrated by this Venn diagram. Conclusive arguments are also presumptively valid, and presumptive arguments are also coherently valid. And all the precedents are either coherent or incoherent. If an argument is incoherent, then it is outside the set of coherent arguments. Every argument can be attached to a label based on its validity in the model. An argument with a conc label are those conclusive arguments. An argument with a pres label is an argument that are presumptively valid but not conclusive. An argument with a co-label is coherently valid but not presumptively valid in the case model. And label inco is used for arguments that are not coherent. These arguments are in the set of all arguments, but not in the set of coherent arguments. We consider the validity labels come with an ordering. Intuitively, based on their validities, arguments with label conc are stronger than arguments with label pres. Similarly, pres is stronger than co, and co is stronger than inco. With this ordering, we can quantify how far apart the labels are. We call the validity distance between two arguments is the number of steps in the validity ordering that are needed to go from the label of the weaker argument to the label of the stronger one. As the ordering has a length 3, the maximal validity distance is 3, and the minimal is 0. For instance, from Kong to Inco, the distance is 3, while from Ko to Ko, the distance is 0. With arguments and their validity labels, we can define issues for discussing the question about hardness. Formally, we represent an issue as sigma plus minus iota, where sigma is a sentence for a given situation. Iota is a sentence as an issue about the situation. Both iota and not iota are not logically implied by sigma. For every issue, there are two naturally associated arguments, namely sigma iota and sigma not iota. For example, when we think of whether to apply the territory rule in tort cases, we consider issue tort plus minus territory, where argument tort territory is for applying the territory rule, and argument tort not territory is for not applying the rule. Similarly, whether to apply the gravity rule in tort law is connected with issue tort plus minus gravity. Whether to apply the exception about the territory rule is connected with issue tort plus minus exception, and whether considering gravity in general is represented with issue tautology plus minus gravity. The type of an issue sigma plus minus iota in the case model C is represented as a multiset consisting of the validity labels of the two associated arguments. For instance, if the argument for applying the territory rule is with label conc, and the argument for not applying the rule is with label inco, then the issue tort plus minus territory is with type conc inco. And by the definition of arguments validity in our paper, not all types are logically possible. Now we show a total 7 possible issue types. And we view hardness of issues, of types of issues, as a relation between types of issues in different case models. Intuitively, a type of issues is easier than another one if and only if the greater the difference between the validity of its associated arguments, or the stronger the validity of the associated arguments. For instance, conc inco is easier than press, since the difference between conc inco is greater than the difference between press. And since the validity strength of press is stronger than inco, we consider press is easier than inco. As shown by the Haas diagram, in our definition, an issue type that is higher in the ordering is easier. Formally, the hardness ordering is based on the lexicographic combination of two orderings among the types of issues. We first compare the types in D ordering. Higher types in D ordering involve further validity distance between the labels within types. And higher in D ordering means the type is also easier. For instance, the validity distance between conc and inco is 3, and the distance between press and inco is 2. Therefore, by the D ordering, we consider conc inco is easier than press inco. However, if the types are with the same validity distance in D ordering, then we can turn to the V ordering. Higher in the V ordering means issues involving stronger arguments. Therefore, higher in the V ordering means the type is also easier. For instance, the validity distance of both type press and co are equal to 0. In this case, we cannot compare their hardness in terms of the D ordering, and we need to use the V ordering to decide which one is harder and which one is easier. Since press is stronger than co in the V ordering, we consider press is easier than co. The Haas diagrams in this slide shows our definition of hardness is well-behaved, since it is transitive and can be used for comparing any pair of issue types. Now we connect the hardness ordering with the development of hardness of applying rules in the New York cases. As we discussed before, the hardness of an issue is determined by the validity of the arguments that it associates with. And with new cases being added, the hardness of applying rules will change accordingly. For instance, the hardness of issue tot plus minus territory is with type Con-Inco in 1938. When it becomes harder in 1963, it is with type Press-Co. In general, we figure out that when the gravity rule was introduced in general in 1954, issue tautology plus minus gravity became harder. Similarly, when the gravity rule was introduced to the tot law domain in 1963, issue tot plus minus gravity also became harder. And we also observed that issue tot plus minus territory became harder correspondingly when the court showed doubt on the territory rule by making an exception for the damages part of a tort case in 1961. And in 1963, when the gravity rule was introduced by a landmark case called Babcock case, with higher preference, not only issue tot plus minus gravity became harder, but also other issues are become easier. After finally making the...
Heng, you have 5 more minutes, okay?
Okay. After finally making the gravity rule as the primary one in 1963, the 4 issues remain the same hardness type Press-Co as in 1938, when the primary one is the territory, and they are all with type Con-Inco. This shows that more options makes the consideration of applying rules becomes harder than in 1938. So in conclusion, we model the hardness of issues of case-based decisions in terms of arguments and their validities, and define an ordering that shows which issues are harder and which is easier. We also apply our approach to discuss the hardness of the issues in the context of dynamics of case-based reasoning. So the hardness approach we introduce is relevant in the understanding of case-based decision-making and can be applied in other domains where example-based reasoning is reasonable. And it can also lead to insights on the hardness of decision-making in hybrid AI systems involving both knowledge and data. Thank you for your attention.
Thank you very much. We have some questions for you. So the first one is, in your paper, the model case-based decision-making is applied in common law jurisdictions. Do you think it's possible to apply this model in civil law jurisdictions?
Yeah, thank you for the question. It's very interesting, but since it's a very initial research, currently we just apply it to the case law domain, but we believe that it can also be applied to the civil law domain because one of our previous paper shows that it can be the case model can also be applied in the Dutch civil law system. So yeah, I think it's possible.
Okay, and another question. There are earlier attempts to formalize the distinction between hard and easy cases. For example, Gordon in 1991 and Preke in 1993. Gordon also formalized the notion of an issue. What does your approach add to their work?
Yeah, it's a very interesting question. Thank you for that. But I haven't looked at Gordon's work yet. So yeah, our approach is based on recently developed case model formalism by Bart. So yeah, it's in a formal propositional logic. Yeah.
Okay, thank you very much. Do you like to say a few more words before we go to the other panelists?
Yeah, I think that's it. Thank you for attention.
In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the cases we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Sorry, could you please repeat the questions?
Okay. In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the case we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Oh, yes. Thank you for the questions. That's for the, if I understand correctly, you mean there is a statement in our discussion sections. That's for the very initial observations of our approach. So yeah, I think that could be interested for future research. Thank you. And I would also like to make a further response to one of the questions from my early presentation. It's from Professor Henry Prakken and about a paper from Thomas Gordon's 1991 paper and Prakken's 1993 papers. So comparing our approach to Gordon's work, our definition of issues share a similar intuition with his notion, but the mechanism behind our approach and his approach is quite different. And in Gordon's work, he simply distinguished cases into two categories. However, in our approach, there are 7 kinds of hardness. For Henry's work, he also connects hard cases with 2 arguments of which their conclusions are opposite, which is similar to our definition. But the purpose and the applied theory of his paper and ours are different. We have a special focus on how to formally identify the types of hardness, while it seems that Henry doesn't formalize the hardness directly. But we all still really thanks Henry's questions. It's very valuable to our further research. Yes, please. Now I'm ready for further questions.